else?
1:15, whatever that day is yours.
9:15? All right.
1:15.
Oh, yeah, the
Oh, the
September
date,
is, yeah,
9:15.
9:15.
No.
Yeah,
Okay.
all right.
Excellent.
Melissa just texted me to let us know we're on an open mic. So.
I got that.
Okay.
Judge has to sign before he comes out, so.
O'Connor. We're presenting the matter of State of Ohio versus Michael Polinsky Jr., case number 25 CR 0000472. The defendant is present in court with defense counsel Rush O'Connor. We are here for purposes of a change of plea hearing. On May 23rd, 2025, the defendant was indicted on a 5-count indictment. All discovery has been provided to defense, and it is the state's understanding that today, pursuant to plea negotiations, the defendant wishes to withdraw his previously entered plea of not guilty, enter a plea of guilty to count 1, trafficking in a fentanyl-related compound, a felony of the 5th degree, count 2, aggravated trafficking in drugs, felony of the 3rd degree, count 3, trafficking in a fentanyl-related compound, a felony of the 5th degree, and an amended count 4, amended to remove the statement that the amount of the fentanyl-related compound equals or exceeds 1 gram, but is less than 5 grams to wit 1.09. That amended count would then make that possession of fentanyl-related compound a felony of the 5th degree, and that count has an attached forfeiture specification as well that the defendant would be pleading to. There is no sentencing agreement at this time. Thank you.
So this is a little different from the original offer at the pretrial.
Yes,
correct?
that is correct.
Mr. O'Connor, does that all sound accurate?
Yes, Your Honor. I would say that is an accurate assessment of the agreement that's been made. I went through that agreement prior to today with Mr. Polinsky, and then upon having the written plea of guilty, I did go through that, explain to him his rights in regards to this matter, that we'd be waiving those rights with this agreement. I as well went through with him the potential penalties on this matter, but we are still in agreement, and he is prepared to go forward with his change of plea.
Thank you. And Mr. Polinsky, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty to 4 of these charges and plead guilty to 4 separate offenses here. The remaining count would get dismissed pursuant to the agreement. We would defer sentencing to a future day to get some reports completed, come back in a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
29?
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
Take Prozac and Clonidine
And you've had those in the last couple of days?
at 9 o'clock at night yesterday.
Now, do either of those two medications that you took last night affect your ability to understand or appreciate where you are, or what's going on around you, or
No.
communicate or anything like that?
Nope.
Now, you should have, you did receive a copy of this indictment. Looks like you got it at the end of May. It's the document that sets forth the specific charges you're accused of committing. Do you remember getting that?
Yes.
And at some point you had a chance to look that over?
Yes.
Now, in that indictment, you are charged. Let me get that up here. In the indictment, you're charged with 5 counts, you're pleading guilty to 4 charges. I'm going to go over those charges with you. In count 1, what's alleged here and what you'll be admitting to is on or about January 30th, 2025 in Menor Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. The amount involved was less than 1 gram, which makes the offense trafficking in a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about it?
No.
Now, in count 2 here, what's alleged and what you'll be admitting to is on or about January 31st, 2025, in Menor Lake County, Ohio, that you did knowingly sell or offer to sell methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount of that methamphetamine equal or exceeded the bulk amount, but was less than 5 times the bulk amount. Specifically, it was 3.68 grams, which makes the offense aggravated trafficking in drugs, and because of the weight, it's a felony of the 3rd degree. Do you understand what it is you're pleading guilty to in regards to count 2?
Yes.
Any questions about it?
No.
Now, in count 3, what's alleged and what you're admitting to is on or about February 13th, 2025 in Menor Lake County, Ohio, that you did knowingly sell or offer to sell a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. The amount was involved was less than 1 gram, which makes the offense trafficking in a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes.
Any questions about that?
No.
Lastly, in count 4, what you're charged with here is on or about April 3rd, 2025 in Mineral Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or some mixture, preparation, or substance containing a fentanyl-related compound. And it's alleged that the amount of the fentanyl-related compound was over 1 gram. It was 1.09 grams. So that conduct constitutes the offense of possession of a fentanyl-related compound. It's a felony in the 3rd degree, and that's what you're charged with. That's not what you're pleading guilty to. That's what you're charged with. You understand that?
Yes.
Now, for purposes of the plea today, the state has agreed to amend this count and delete the language that the amount involved was over 1 gram. And by deleting that, what it does is reduces it from a felony of the 3rd degree to a felony of the 5th degree. A felony of the 3rd degree is more serious, much more serious than a felony of the 5th degree. So you'd be pleading guilty to the possession of a fentanyl-related compound without the allegation that it was over 1 gram, so it would be a felony of the 5th degree. So do you understand what you're going to be pleading guilty to?
Yes.
Understand the difference between the two?
Yes.
Any questions for me?
No.
Now the charge also carries with it, excuse me, what we call a forfeiture specification, which alleges during the commission of the offense you possessed or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's just illegal by the very nature of the property itself, whereas an instrumentality is some type of property. It may not be illegal, but it's being used for an illegal purpose or in an illegal way, and you can't possess it for that purpose. And here it's alleged it's all the drugs and the packaging and the paraphernalia that was seized. That's the contraband and instrumentalities. And the whole point of this is that you just forfeit any ownership interest you have in it so that they're able to destroy it. They, meaning the state, can destroy it at the end of the case. It doesn't increase any potential penalty you face. You understand that?
Yes.
Any questions about it?
No.
So you understand the nature of the 4 charges you're pleading guilty to?
Yes.
Any questions about any of them?
No.
Now, there is a 5th count that's being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about that?
No.
Well, then before I can accept your plea to the 4 charges I just reviewed with you, I need to make sure you understand all the rights you are giving up. And you first of all have a right to have a trial. Now that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to have a jury trial in this case?
Yes.
Now, if we did have a trial, the prosecutor who would represent the state of Ohio, she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes.
Do you understand that by pleading guilty, you're giving up your right
Yes.
to, let me finish, I'm sorry, I know I paused. You're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted to. Understand that?
Yes.
And you further can request the court issue an order, and we call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right.
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, prosecutors now to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we did go to trial and you were found guilty of any of these charges, you would have a right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could raise or brought to my attention up to this time. You understand that?
Yes.
All right, well, do you have any questions about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
You understand them all?
Yes.
And you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the be that you didn't do it, or it's someone else's fault, or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty in count 1, 3, and the lesser included offense of count 4. Those are each felonies of the 5th degree. Felonies of the 5th degree are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, count 2 is a felony of the 3rd degree. That's the methamphetamine charge that carries with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if I impose the prison sentence in that case, I'd instead select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for that count. Do you understand that?
Yes.
Now, since there are 4 separate charges here that now occurred on, there's different dates, different incidents. If I impose a prison sentence, I would impose a sentence or a term on each count, and then as the judge, I have the discretion to run those terms concurrent or consecutive. Concurrent means together, that you serve them at the same time. Consecutive means one after the other. You serve the prison term on the first count, complete it, then the next, and so forth, for whatever sentences are consecutive. Understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count, and I ran them each consecutive, you're looking at a maximum possible prison sentence of 6 years or 72 months in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No, Your Honor.
I understand you do have other charges pending against you.
Yes.
That's here in Lake County.
Yes, I have arraignment tomorrow.
Anywhere else?
Not that I know of.
If a prison sentence is imposed in that case, and you were also being sentenced for the new case, if it got to that point at the same time, or if for whatever reason you were sentenced to prison in the new case before this one, which I don't see that happening. But if that were to happen, if I impose a prison sentence in this case, I could run the sentence concurrent or consecutive to that sentence. Now, that could only be done if that sentence has already been imposed or is being imposed at the same time as this case. I can't, if that case is still unresolved when we come back here for sentencing in this case, then I can't do that. I can't run a sentence concurrent or consecutive to some future possible unknown sentence. It's got to be already in place or being sentenced at the same time. You understand that?
Yes.
All right. Now, if a prison sentence is imposed in this case upon your release from prison, you could be placed on what's called post-release control. It's sometimes referred to as parole. And that is a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control and you were violating any conditions of your supervision, you would have a hearing. Now, I'm sorry, the parole board would have a hearing to see if you did in fact violate, and if you did, they can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Bless you.
Excuse me.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined in this case. In fact, one of the counts carries with it a mandatory fine. Count two, the felony of the third degree, carries with it a mandatory fine of at least $5,000 that must be imposed, but you could be fined up to $10,000. Do you understand that?
Yes.
The other three counts all carry with it a possible fine of $2,500 each. Do you understand that?
Yes.
So altogether, a fine of at least $5,000 will be imposed, but you could be fined up to $17,500. Do you understand that?
Yes.
And you could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes.
Also, there's a possible driver's license suspension that could be ordered of up to 5 years. Do you understand that?
Yes.
And lastly, as I alluded to earlier, any right, title, or interest you have in any of the property that was seized during the investigation would be ordered forfeited at the time of the sentencing. You understand that?
Yes.
All right, now a few moments ago I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory. In this case, you are eligible for probation, or what is referred to as community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on community control sanctions? It means I'll consider that if that's what you're asking for. I'll look at all the information that gets presented, then I'll make the decision I think is the right thing to do. You understand that?
Yes, Your Honor.
Now, while the offenses are probationable, count two, the methamphetamine charge is a felony in the third degree. There is a presumption for prison in that case, which means I have to impose a prison sentence unless I can make certain findings that override that presumption and allow me or permit me to impose a community control sanction. Do you understand that?
Yes.
Now, if you are on community control sanctions, it could be up to 5 years, and as a judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes.
Further, if you ever were on probation and you violated the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did it, again, it could be for the period of time on each count that I mentioned earlier for an overall total of up to 6 years. You understand that?
Yes.
And that could be, again, consecutive to any other sentence you may be serving at that time, or that you're being sentenced for at that time. You understand that?
Yes.
All right, lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you'd like me to know or consider. Your attorney can speak on your behalf. He can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I did not think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No.
Do you understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to go over this case with your attorney and have him review everything with you, answer your questions, go over the reports, whatever, everything?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then. Any questions from me at this point regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to talk with your lawyer?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show at a trial if we went forward with the trial. I need you to listen to her because I have some questions for you about that, all right? All right. Mr. Ronick?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that in count 1 on January 30th, 2025 in Menor Lake County, Ohio, the defendant did knowingly sell a fentanyl-related compound, which is a Schedule II controlled substance. In count 2, that the defendant on January 31st, 2025 in Menor on the Lake County, Ohio, knowingly sold methamphetamine, a Schedule II controlled substance. The amount of that methamphetamine exceeded the bulk amount, was less than 5 times the bulk amount, specifically 3.68 grams. In count 3, that on the defendant on February 13th, 2025 in Menor Lake County, Ohio, did knowingly sell a fentanyl-related compound, a Schedule II controlled substance. And in count 4, that the defendant on April 3rd, 2025 in Menor Lake County, Ohio, did knowingly possess a fentanyl-related compound. Specifically, Your Honor, for counts 1, 2, and 3 on each of those dates, the Menor Police Department had utilized a confidential informant to conduct controlled buys with the defendant on each of those days. The defendant did sell drugs to that confidential informant. For count 1, it was 5 fentanyl pills that contained fentanyl, dispropyl fentanyl, and had pharmaceutical identifiers for oxycodone, but were not actual oxycodone. In count 2, the defendant sold that CI 3.68 grams of methamphetamine, Schedule II. And in count 3, the defendant sold that confidential informant another 5 pills that were found to be fentanyl and dipropanol fentanyl, again with pharmaceutical identifiers for oxycodone, but not actual oxycodone. On April 3rd, 2025, the defendant was arrested on a warrant for these controlled buys and had on his person at that time 10 blue tablets, which were found once again to contain fentanyl, dispropyl fentanyl, both Schedule 2, again with pharmaceutical identifiers for oxycodone, but that were not oxycodone, as well as 0.86 grams of cocaine Schedule 2, a plastic straw with residue containing cocaine and fentanyl, and a smoking pipe with cocaine residue. Thank you.
Thank you. So, Mr. Polinsky, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show in this case if we went forward with the trial?
Yes, Your Honor.
And what, if anything, you had to say about those facts as she presented them to the court? Are they true? Did you do what she said in those instances?
Yes, Your Honor.
Very well, then. Regarding count 1, charging you with trafficking in a fentanyl-related compound, as well as count 3, charging you with trafficking in a fentanyl-related compound, both felonies of the 5th degree. What is your plea to each of those 2 counts?
Guilty, Your Honor.
Regarding count 2, charging with aggravated trafficking in drugs, a felony of the 3rd degree, with the drugs being methamphetamine, a Schedule 2 controlled substance, over the bulk amount. What is your plea to that?
Guilty, Your Honor.
And regarding the lesser included offense of count 4 being possession of a fentanyl-related compound, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which sets forth everything we just talked about, what you're pleading guilty to, the rights you're giving up, the penalties you face. Before I can accept your plea, I need to make sure you understand that document, that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. O'Connor, is that accurate? Did you review that with Mr. Polinsky, answer his questions?
Yes, Your Honor, I did go through the documentation downstairs with him, as well as in the courtroom.
Did he indicate an understanding of it to you when you did that?
I believe he had an understanding, and I answered any questions that he had, and he had no further questions upon signing it.
Is that correct, Mr. Polinsky?
Yes.
So you do understand it?
Yes.
Any questions for me about it?
No.
And as was alluded to, and it appears in the document, it looks like you signed it. Did you sign it?
Yes.
Can you witness that, Mr. O'Connor?
I did, Your Honor.
And Ms. Ronick?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant does understand the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea and find the defendant guilty of count 1 and count 3, each trafficking in a fentanyl-related compound, each felonies of the 5th degree, and each in violation of 2925.03A1. Court will further find the defendant guilty of count 2, aggravated trafficking drugs, a felony of 3rd degree in violation of 2925.03A1, as well as the lesser included offense of count 4, being possession of a fentanyl-related compound, a felony of 5th degree in violation of 2925.11 with the forfeiture specification. Count 5 will get dismissed that's sentencing. I'm gonna defer sentencing, however, I'm gonna order a pre-sentence report investigation, drug and alcohol evaluation, bond be continued. Is there anything else at this point for behalf of the state of Ohio, Ms. Harana?
No, Your Honor, thank you.
Mr. O'Connor?
Nothing else, Your Honor.
All right, thank you.